everybody.
Can I have your name, please, in the Otsego County Jail?
Brian O'Neill.
Okay, I thought you were Mr. O'Neill. I just wanted to make sure. So we're on the record in the matter of People versus Brian David O'Neill. This is file 24-6744FH.
For the record, Mike Roll on behalf of the people.
Thank you, Your Honor. Richard Trish on behalf of Mr. O'Neill.
Thank you. So, and ma'am, for the record, you are Candida Nelson, correct?
Yes, sir. Yes, I mean, Your Honor.
Welcome, Ms. Nelson. I recall your name and your involvement with this case, obviously not only through the briefing, but because you spoke as the victim of this offense at Mr. O'Neill's sentencing. So we're here because at the sentencing hearing, the issue came up about potential forfeiture of the weapon involved. And I asked the attorneys and required the attorneys to brief that issue. I've now had a chance to review the defendant's brief and request for relief regarding the firearm forfeiture, as well as the prosecution's brief in response to the defendant's motion regarding forfeiture of the firearm. The court knows that I've examined those each in detail as well as the statutory framework under MCL 750.239 in its entirety. And under this situation, while this isn't necessarily a motion, it's a follow-up brief that I required. I also would note that my discretion is simply given the fact that it's still a motion and a request. My discretion allows for me to exercise the discretion by barring any further oral argument. I intend to do that today. The attorneys have set forth in their written briefs their positions, and it's ready and ripe for a court determination based upon the circumstances and based upon my view of the statute. So the court notes that first, the statute in question, MCL 750.239, although the defense indicates that it authorizes forfeiture, I view it a little bit different. It requires forfeiture for firearms used in the commission of a crime, and that's because it is used as mandatory language like shall. The operative question, though, for the court is under 750.239, subsection 3, is not about forfeiture, it's about before disposal. And so the court notes that there are several different points that I disagree with, particularly in the prosecution's brief. For example, in the prosecution's brief, there was an indication that there was seizure of a Springfield Armory XDS 9mm from a residence by the Gaylord City Police, and that there was never any formal claim of lost or stolen firearm ever filed by Ms. Candida Nelson with the Gaylord Police Department. The court finds that such a citation, though, turns the statute essentially on its head. And it does so because this is not a situation, and the statute doesn't envision a situation where Ms. Nelson had to make any formal claim with the Gaylord Police Department. Instead, the facts clearly elucidate the fact that at the time this offense was committed by Mr. O'Neill, Ms. Nelson reported that her gun was missing from her safe, and that is enough to trigger a police investigation. There is nothing in the statutory framework of 750.239 that requires Ms. Nelson to incantate specific words or language, or to use the words lost or stolen in order to have the police investigate. She didn't use that language, and the police didn't do anything other than investigate on the basis of her claim that her firearm was missing. Police officers clearly and unambiguously understood that the report from Ms. Nelson was that somebody, likely Mr. O'Neill, took her firearm without permission and destroyed her home. At no point did the police ever suspect Ms. Nelson of wrongdoing. At no point did they ever charge her with the crime. At no point did they ever consider her to be a suspect, because she clearly and articulately reported that her firearm was missing. Mr. O'Neill was clearly then found to have been the one who perpetrated the damage. He pled guilty to doing it. Ms. Nelson, at all times, even during the Crime Victims' Rights Act involvement with the case, was viewed as the victim. She allocated as the victim. Again, nothing has changed that status whatsoever. So the question really becomes under the statute whether or not, as the attorneys argue, whether or not I should find that Ms. O'Neill, or excuse me, Ms. Candida Nelson, has somehow failed to do the things that she's required under the statute, or whether, on the other hand, I find that the Michigan State Police has failed to do what they're clearly required to do. I make the determination that the latter applies and not the former. Any error that's been made in this case has not been by Ms. Nelson, the victim of this crime. It's been by the Michigan State Police and or the prosecutor's office, and I say that this way. The statute, MCL 750.239, requires that before disposing of a firearm under the section, the director of the Department of State Police shall do both of the following. In other words, that statutory section mentions nothing about any requirements on behalf of the victim of a crime, Ms. Nelson. It instead clearly and unambiguously requires the state police to do both of the following. First, to determine whether, through law enforcement information network, whether the firearm has been reported lost or stolen. If it has been lost or reported lost or stolen, and the name and the address of the owner can be determined, The Director of State Police shall, again, mandatory language under the statute, shall provide 30 days written notice to his or her intent, of his or her intent to dispose of the firearm under the section of the owner, and allow the owner to claim the firearm within that 30-day time period. Nothing that I've been provided in the defense brief or the prosecutor's brief indicates a compliance with that statute in any way. First, the prosecutor takes issue with and claims that there was never any finding that there was a report of lost or stolen. I find that to be hyper-technical, not fair, not reasonable given the circumstances, based upon the victimhood of Candida Nelson, of which the prosecutor's office is well aware, particularly because this was a crime victim defense, and the crime victim's advocate working on behalf of the prosecutor's office worked directly with Candida Nelson as a victim of this crime. I find that any hyper-technical request to have the words lost or stolen used is not in the interest of justice, and it does not echo the statutory language, which is clear on behalf of the director's duties under the Department of State Police. In other words, as soon as Miss Candida Nelson reports that her firearm is missing, the duty before there's a disposal of the firearm is on the state police to make notification here to Candida Nelson that she is the known owner of this firearm because she reported it to the Gateway Police Department as missing. That duty is clear, and it provides then Miss Nelson with 30 days to claim the weapon back under the otherwise known as the innocent owner exception. Even if the state police didn't fulfill its obligations, and it appears that they have not under that section, the next section is additionally applicable and provides an additional 30-day requirement, 30-day notice requirement to the public. Nothing in the information provided by the prosecutor's office, nothing provided by the way of the defense brief suggests that the Department of State Police has yet provided that notice to the public. And so the court notes that even if I were to follow the prosecutor's suggestion, which is at the end of the brief, prosecutor's claim and suggestion is that for all of the above arguments in law and fact, the people respectfully request the defendant's motion for request used by the defendant in the commission of this felony offense be denied, and that the Springfield Armory XDS 9mm semi-automatic pistol be ordered to be confiscated and condemned pursuant to the statute 750.239. The court notes that this creates, if I were to follow the prosecutor's suggestion, an unworkable, untenable, and fairly silly example. Because if I were to order confiscation and condemnation, then the state police requirements under 239.3 still are at issue, and they still require the state police to provide notice, number one, to Ms. Nelson, who then can recover the firearm if she's otherwise allowed to possess it, and the state police still has to provide 30 days notice to the public, where then, if the serial number can be determined, the owner can come forward, demonstrate that she's authorized to possess a firearm. In either scenario, even if I were to find that the hyper-technical argument by the prosecution that because Ms. Nelson didn't incantate the correct words, lost or stolen, somehow deprives her, the victim, of being able to recover her firearm that she had nothing to do with the illegal nature of, the state police would still have the same duty if I followed the prosecutor's own requirement to order confiscation and condemnation. I don't choose to do that. Instead of my discretion, I choose to make a clear finding and a clear ruling that the firearm in question, the Springfield Armory XDS 9mm, shall be released to Ms. Nelson as soon as she demonstrates that she's lawfully able to possess the firearm. If for whatever reason Ms. Nelson can't lawfully possess a firearm, of course it won't be able to be released to her. But the statutory parts are clear and unambiguous. I don't frankly understand why in this position, why the prosecutor's office is clearly aware that the victim is a victim, that they would take the position that the victim should somehow be additionally punished because of the criminal actions of David O'Neill. I don't understand it, but it's not up to my understanding. That's the prosecutor's position. I simply overrule it, and I grant the defense request to have Ms. Nelson permitted to retrieve the firearm again once and if she's able to demonstrate that she's authorized to possess the firearm. Mr. Tush, can you prepare an order?
Yes, Your Honor, I certainly can.
Do you have questions about the specific language that is specifically that Ms. Nelson is allowed to and required to, or permitted to rather, retrieve the firearm, but she must demonstrate that she's authorized to possess it? Do you need further clarification on that language?
I do not, Your Honor.
Do you have any statements for purpose of appellate review that you'd like to place on the record, Mr. Church?
No, Your Honor.
Do you, Mr. Rolo?
Yes, Your Honor, thank you. It's not the people's position that the statute was implicated as the weapon was found in the defendant's home, in the master bedroom, on her bed, in the room she would share sometimes with the defendant. The weapon was never stolen or lost in the first place. That's why the people took the position they did. Thank you, Your Honor.
So noted. Ms. Nelson, what you'll need to do is once you have a copy of the order that Mr. Trush is going to provide, I'm going to sign, is take yourself to wherever that firearm is being held. And I'm sure that now, given the order, even if the prosecutor disagrees with it, he'll accommodate and let the defense attorney know where the firearm is being housed. Is it at GPD? Do you know, Mr. Rolla?
That's my understanding. It's in their gun lockup. Yes, Your Honor.
All right, and so you'll have to coordinate with Mr. Trush and hopefully with the assistance of Mr. Rolla to find out exactly where you need to go, Ms. Nelson. But as long as you can demonstrate that you're lawfully entitled to the weapon, you should be able to retrieve it. Do you have any questions, Ms. Nelson?
This is my only firearm that I have currently. I have been in the process of purchasing another firearm, just because to have protection in my home. But since, yes, so no, I own no other firearms currently. Correct.
Okay, thank you. Mr. O'Neill, thank you for being here today. I know you were brought up by request of your attorney. The court will be at recess on this matter today. Thank you, everyone.
Thank you, Your Honor.
All right, this Camp or Colin Camp? All right, Mr. Camp.
Yes,
Okay, Mr. Camp, do you have an attorney at this time?
just my court-appointed counsel that has not been made aware that I'm back in court. And I've not been allowed to make any phone calls.
Okay, this is a motion for revocation is what you've been picked up on.
Yeah, 30 days after I was supposed to be released from it.
All right. Well, this is your first appearance on that. This was,
This was filed after.
I'm not taking up the merits on it. Mr. Camp, you do have the right to be represented by counsel. You'll need to resubmit an application. Judge Satterfield is the judge that this matter is assigned to. She placed a no bond interstate compact on this case. I'm not inclined to modify that. Additionally, all right, now looks like you were represented by Mr. Cooper, is that correct?
Correct.
Was there any conflict there? Any reason why he can't represent you again?
Besides not being able to get a hold of him, no.
All right. Fill out the application for court-appointed counsel. I'll review that. You can do that today. I can review it today. If you meet the criteria, I'll appoint an attorney to represent you, and we'll set that on Judge Satterfield's docket. Aaron, do you have a proposed date?
I do, Judge. That would be March 20
I would request that be much sooner
at 9 a.m.
so that I can have a fair and speedy, trial.
Well, Mr. Camp, I don't control Judge Satterfield's docket. What I suggest that you do is get that application for an attorney turned in. I'll review it today. If you get that done, if you had court-appointed counsel before, are you employed at this time? Did you have any funds available for an attorney?
I was employed until this happened. And as a result of this, I lost my place to live and my job. And it could have just been like a phone call probably. But
Judge, I've signed a new complaint on the new charges already that are being filed today from over the weekend or this last week.
Well, I'll review that as when it comes to me, but I don't have control of Judge Satterfield's docket. You can speak with your attorney. You're probably going to qualify for an attorney. I intend to appoint Mr. Cooper if you meet the criteria, and then you can contact him. He'll be notified that you're in jail, And-
Unfortunately, I'm not able to even make phone calls from this jail.
Well, like I said, he'll be notified, your attorney will be notified that where you are so they can contact you and make arrangements in regards to discussing the matters with you.
Okay, well, there's nothing I can do besides what they allow me here, so.
All right, very well. So March 20th at 9, unless it's modified later, but that's in front of Judge Satterfield. Anything further on this case?
I would just request that it be sooner than that, much, much sooner.
I understand. I've addressed that issue. So with that, we are adjourned and he can be taken back to his cell.
Be safe, be well, sleep sweet, and much love.